actually start by saying that, my Lord, the President of the Court of Appeal, Justice Monica Dongban-Mensem, was invited for this program, and although she's unavoidably absent, my Lord had actually put together a small presentation, which she has asked me to present at this occasion. If, Planet Silk, you do not mind, I want to quickly do that.
Go ahead, sir.
Thank you very much. So, what you hear from now is the position of my Lord, the President of the Court of Appeal. My Lord says, I thank the organizers of this event, the Justice Research Institute, the moderators, Mr. Olubunmi and Professor Ayo Atsinwa. I must remind us first that the appointment of judges, for all the criticism that has been leveled against it, is more transparent in many respects than it was in the past. I recount an anecdote that was given by the Honorable Justice Kayode Esho of blessed memory in his book, when his lordship noted that the Chief Justice of the Western Region has simply recommended his name to the Premier for appointment as an acting judge based on the conduct that he had demonstrated in practice and in his appearance before his lordship. The Chief Judge is recalled having told the shocked Honorable Justice Kayode Esho that the reply to my recommendation arrived yesterday and the governor will be ready to swear you in next week. The instrument is already prepared. It is further recalled that the Chief Judge of the whole Western Region then said, you do not need to be grateful to me. It is your work that has done it. The judges there have had an eye on you for some time. They report so favorably on your brilliant performance. In the old days, judges were able to distinguish between lawyers who had preponderance to be corrupt or engaged in other untoward practices, as against those who meticulously and diligently prosecuted their cases within the confines of the law and the rules of court. Furthermore, an invitation to legal practitioners was meant for only those who were genuinely interested in making a career on the bench. Such appointees were invariably comfortable financially, and those who are less likely to be corrupt and would strive to preserve their reputation and their names. However, the increase in the number of lawyers and the multiplicity of courts means that not all those who apply as candidates to the bench will have had sufficient courtroom experience. One of the more pungent criticisms that have been leveled against recent appointments is the relative lack of trial experience and know-how of newly appointed judges. This has led to further allegations that judges were appointed on the basis of factors that had little to do with their competence. Hence, there was a need for the revised guidelines and procedural rules for the appointment of judges, of judicial officers of all superior courts of record 2014, which the NJC put together. His Lordship said further, in my opinion, the NJC guidelines are fair in their purpose, which is to ensure that the selection process is transparent and provides a level playing ground for free and fair selection for the best candidates, guarantees independence of judicial commissions, excludes lobbying by potential candidates or anyone on their behalf, and prohibits imposition of any candidates on judicial service commissions. 3, the decisions of all those nominating and or recommending candidates to National Judicial Council take fully into account the necessity for the candidate to have high integrity, good reputation, track record of intellectual capacity, competence, and work and industry in the legal profession, record of reasonable successful background in legal practice as private legal practitioner or state counsel of service in the lower bench, and commitment to justice and an absence of likelihood of bias on the grounds of tribe, ethnicity, religion, politics, or gender. I shall not bore us all with the rudiments of the rules, but suffice to say that the rules have by and large been successful in sanitizing the process of appointment into the bench. However, no system is perfect, and in some cases, we may have a lot to learn from the best practices in our fellow Commonwealth jurisdictions, so than the United Kingdom and the Republic of Ghana. I will, however, concede that in actual practice, the most successful candidates or judges have often tended to be those who have proven competence and trial room experience. They have interacted with clients either as plaintiff or the defendant. They know the evidence is required to tip this case, and they are tuned with evidential rules of the court. The need for competence and high integrity above all other considerations must guide any appointment process, because for all the quirks of appointment and in the old days, only the best were permitted to be on the bench. This, I believe, should underpin the system of appointment, whether in Nigeria or elsewhere. And I think that that is the fulcrum of our discourse today. To conclude, I wish to say that in the Court of Appeal, where I have specific responsibility for presenting candidates, I have put in place a system to ensure that federal character as required by the Constitution does not trump competence. While experience is very important, seniority will not be allowed to displace competence, and truth be told, a judge that is not IT compliant in this day and age is at best a liability. Under my leadership, the Court of Appeal will not be a dumping ground for trial judges who only seek to prolong their careers or unwilling candidates simply nominated to get them out of the way for favored candidates of the political leadership of states to emerge as chief judges. Essentially, the process that I put in place for the selection process in my court is designed to be sufficiently rigorous to allow for candidates possessing integrity, competence, and industry to emerge. Finally, may I suggest that the organizers go a step further to put together a stakeholders forum involving members of the various bodies charged with the appointment of judicial officers in Nigeria, to wit the National Judicial Council, Federal Judicial Service Commissions, State Judicial Service Commission, and that of the Federal Capital Territory, including the appointing authorities, as well as the Judicial Committee of the National Assembly, to rub minds towards achieving synergy and a common vision on this issue. I thank you all for your attention. That is the position of the President of the Court of Appeal. If time permits later in the program, I may now chip in one or two things on my personal account. Thank you very much.
I think it's one that I would direct to, and I'm happy the speaker is still here. The Chief Justice of Kenya was appointed through a transparent and competitive process, monitored by an independent commission, which itself was occupied by men of integrity. So it is couched. Will Nigeria consider such option, even if it means amending the constitution? Because that Chief Justice said drove reforms fundamentally in Kenya. This is directed to Justice Oyewole, and I'm sure the speaker might want to say one or two things about it, but my Lord Justice Oyewole, please.
Thank you, Lana Silk. I believe that, as my Lord Justice Augie said earlier, I totally endorse that position that the process is such that we must look for the very best everywhere. Now, at the moment, for instance, I can speak because we are trying to appoint new justices to the Court of Appeal. The letter that was sent out asking for nominations actually included the point that you may be invited to defend your nomination. So you just don't nominate anybody simply because you think the person is close to you or has lobbied you. You must be able to speak to the person's competence, the person's integrity. Now, putting in place a transparent process, we presuppose that what we have now is less transparent. But we also need to interrogate what we have now. Earlier on, when a presentation was being made earlier, I think it was Professor Konsola Ajayi, he made mention of the fact that non-laymen are not involved in the process. Laymen actually involved in the process. All the judicial service commissions of the states have laymen as members. National Judicial Council, the Federal Judicial Service Commission have laymen, non-lawyers, as members. So we actually, constitutionally, laymen are actually involved in the selection process. What I think we need to do more, because as they say, the philosophers have interpreted the world. The point is to change it. When we look at what we have put in place on paper, it looks so good. Walking the talk is what we need to do. I recalled that when, during the selection process, we brought me to the Court of Appeal, my Lord Justice Amina Ogi was the presiding justice in Lagos Division. She sat on one of my judgments. She did not have any personal interaction with me. My Lord called the other justice and said, look, we have sat here. This person is deserving. Let us recommend him. I only got to know of that much later. That is the type of process we're talking about. Going all out to head-hunt, look for materials, whether in or outside, and But the process that we have now already provides and allows for it. It's only a question of people walking the talk and being true to the process that have been put in place.
My Lord, thank you very much for that response. I probably will go one step further. That was the process that was known. I remember Justice Obaseki telling me that Unemeka Agu came to the Supreme Court through that process. They were so impressed by his dissent, as a matter of fact, not his judgment with his brothers. And they said, look, we think this gentleman should join us in the Supreme Court. Now, the problem is vague words like integrity. And you will have, and I think this is what Wifo said, you will have this particular process that is not defined. It will provoke and bring out the best, but it would also bring out the worst, because there might be justices who sit there and perhaps they've gotten there through a different means. They will not recommend you in that manner. So we need an independent process. And I think that is the, that is really the crux of the matter. But let me, Prof. Ayo, do you want to put the next question so that I don't?
Yes. Well, actually, I have a question in relation to the presence of lay persons in the Judicial Service Commissions and the NJC. I'm thinking, so could we say that the problem is with the process that throws up the particular lay persons? So maybe we need to look at that. Maybe we need to ask the bodies, maybe the citizens, to vote the lay persons who would be appointed to those commissions. Maybe we need to leave the decision of who's representing the NBA to the NBA, who's representing the NBA, or maybe the NJC to the NBA, and not to any other person. So I'm just thinking that, yes, we do have something that looks like it could work, but maybe it needs some tweaking. And I just want to ask Justice Oyewole, because he was very particular in noting that, yes, we do have laymen, we do have, well, also there's the issue of the number of the laymen. And there's a question here, says, do you see a day when a lay person can be the chair of the NJC or a State Judicial Service Commission or the Federal Judicial Service Commission? My Lord, do you see that day coming?
Thank you, Prof. I have said it because this is an issue that is really, really important to me. And I had said it at a different forum. The National Judicial Council that we have today is different from what was envisaged by the framers of the 1999 Constitution. Over time, the NJC has evolved beyond even the specific functions given to it under the 1999 Constitution. So there is a need, because the 1999 Constitution created what is at best a Chief Justice Commission. The NJC, the Chief Justice shall appoint, even for the NBA members, the Chief Justice shall appoint on the recommendation of this. I call Chief Judges of State to be appointed by the Chief Justice on the recommendation. So essentially, what we have as the National Judicial Council today is the Council of the Chief Justice of Nigeria. If we need to move from there to an independent institution that may even interrogate the holder of the office of Chief Justice in an appropriate situation, the Constitution needs to be revisited. For the National Judicial Council, again, it seems that it is a consensus that appointment of judicial officers should begin and end with the judiciary, and that executive involvement in the process should be limited. Again, that will require a revisit of the 1999 Constitution, because the 1999 Constitution makes the political leadership the appointing authorities. So we've had instances when National Judicial Council had recommended candidates, the candidates had simply been dropped without any explanation as to why those candidates were not appointed. It happened at state level, it's happened at the federal level. So there is a necessity to revisit the provisions of the Constitution to perhaps capture what we all desire as the process for appointment of independent-minded justices or judges for our judiciary.